Hello, welcome to Legal Action. My name is David Siegel, along with my co-host Jesse Barrientes, and today we're going to be talking about divorce mediation. Jesse, welcome to the show. Good to see you.
Thanks, Dave. You too.
And Jesse, you are a mediator under the court, is that correct?
That's correct. I'm a approved mediator and also a approved mediator for DuPage County as well.
So you're someone who gets called upon to mediate divorce cases at the court's insistence and request?
Right, appointed by the court. Usually selected by the parties, but appointed by the court. That's correct.
Well, let's jump in. This is divorce mediation, so obviously we're dealing with an underlying divorce case.
Right.
How does that start?
Well, initially, there's a breakdown of a marriage, and one party, the husband or the wife, files a petition for dissolution of marriage. The petition gets filed with the court. Most often, it gets placed with service with either the sheriff or a special process server. The other party is served. After that time, they have 30 days from the date they get served to file their appearance and their answer. And then after that's done, there's a whole bunch of different things that need to happen. For example, discovery. I know we've talked about that on previous shows where there's interrogatories, and those are kind of written questions that people have to answer. Request to produce, that means you have to produce certain documents. Generally, they're financial. Right. A lot of times, though, if we're dealing with, and that's where mediation comes in this context, is when we're dealing with visitation and when we're dealing with custody. And maybe we should explain a little bit about custody.
So this is within the divorce case, within the litigation process, somewhere along the line, either the court or the parties or their attorneys decide that mediating this is a good idea.
Well, generally, if there's a custody issue or there's a visitation issue, it's mandatory. It's required.
That's true. So with custody, the court immediately is going to want to know, is there an agreement on custody? And if not, they're going to send them to the court-ordered mediation, which is different from what you do.
That's correct. Actually, I do both.
Okay, but are you on the list of the court-ordered mediators?
I sure am in DuPage.
Okay, so yes. They might see you almost initially to talk about mediating a custody issue.
Right. You mean before the divorce?
Formal mediation.
Oh, before the divorce is
No,
filed.
the mediation
after.
intake.
Right. Yeah, what initially happens is when you go in and there's one of those issues, the judge will, because it's required to go to mediation, and the parties will look at the list. There's lists in different counties of approved mediators. In order to do that, there's extensive training, and each county has some additional steps that you need to take in order to do that. And once you're on that list, and they'll look and they'll select. Generally, the judges really don't appoint the specific person. The parties agree on the specific person that's on there. We were at a seminar not too long ago, and the judges said they rarely appoint somebody. It is the people coming together, the attorneys for either side, and selecting someone on that list.
Right. There's so much misinformation about custody that I have found in my practice that court-ordered mediation initially regarding custody is actually a great thing, because you, as a mediator, are educating the parties as to what custody really means. For example, there's a misconception that the party who does not have custody has no say in the child's life and is just an outsider. And that's just not the case. You can have physical custody where the parent and the child are together, and the non-custodial parent has extensive visitation and maybe even some more issues too. So explain to the audience how that works when they come to see you for custody mediation ordered by the court.
Well, let's talk about, so they know the different types of kind of custody. You mentioned residential custody, or when you have physical possession. There's sole custody, which means that the non-custodial parent, the person who doesn't have the child or physical possession of the child most of the time, does not have a say-so in the upbringing, in the day-to-day decisions, in the decisions that as it relates to medical treatment, and the decision, except for, of course, emergency.
Right. But they still have heavy involvement.
They have heavy involvement.
Extensive visitation, extended periods of time, possibly in the summer and the winter breaks.
They do, but again, people, when you say custody, people can't wrap their mind around it. They think that it's, the other person's getting it and I'm going to be cut out. The other type of custody is joint custody, where the other parent, the non-custodial parent, does have a say-so in the education, in the religion, in the medical treatment of that child or children, and they get to be able to have visitation. I mean, that's different. Whether or not someone has sole custody or joint custody, unless you're a monster, unless there are some other very, very good reasons, you're not going to get, or you are going to get, visitation. That's not going to be an issue. It's not going to be a problem. There is one kind of hybrid, which is more the exception to the rule.
And what is that?
And that would be joint residential custody. And that would be a situation where both parents would share parenting time pretty much kind of equally. But again, I say it's the exception. understand, this is not something that you do because it's convenient for the parents. I mean, that's what they try to do all the time. Everything is determined and dictated by the best interest of the child or the children. And so if it's a situation where it works, a lot of times people, even though they might get divorced or they're going through a divorce, they'll still stay in the same home. And so in a situation like that, you know, that might be appropriate. They may continue to stay in the home after the divorce for a certain number of time before they put the house up, especially now because the market is so horrible. Or somebody might live very close and they're in the same school district, and that's the schedule they've maintained so far, and it naturally flows. But
the court needs some serious convincing, though, to allow that kind of arrangement.
Right.
Because you are still shuffling the child back and forth from one household to the other, even if they're in the same school district, even if they're in close proximity. It's not like sharing a pet where you're going to care for the pet 4 days, I'm going to have them 3. It's much more involved than that, especially with the schooling and extracurricular and whatnot.
That's absolutely correct. That's why it's the exception to the rule. It doesn't work all the time. And again, and I'm stressing that everything is the best interest of the children, not the convenience of the parents. And a lot of times that's what they try to do to make things more convenient for them, and they're losing sight of what it is. But as it relates to that in visitation, obviously getting to see your child or having parenting time for a specific time, a kind of general type of parenting time schedule or visitation schedule would be every other weekend, alternating holidays, meaning that one day the husband, or one holiday, one Christmas, the husband would get Christmas, the following Christmas the wife would get it, and they kind of break it up and alternate.
And
then
that's
you have
easy
spring
enough
break.
to do with a
That's easy enough
schedule
to do.
that calls for odd, even years and things like that.
Right.
A lot of times, let's talk about men in this circumstance where they get the extended visitation, where they might not even exercise the visitation, but at least they have the right to have that extended visitation. Have you seen cases like that where a woman, a custodial mother, will say, he's not exercising the visitation, therefore I'm going to refuse it now?
I've seen certainly the first half of it, and what's really funny is I just yesterday, someone came into my office and asked me if he had to exercise his extended visitation. And my response was, well, they can't make you exercise visitation. You know, it may prejudice your rights later on, but they can't make you. However, these are your children,
Right.
And if
It's
you
damaging.
can spend the time, if you're on an oil rig for work or something like that, or some out of state, okay, that's understandable, and you do what you can. But those are your children, and there really needs to be a connection, even after the relationship and the marriage has been severed, with both of the parties. That's really the only way to ensure a healthy
And the children
growth.
come to expect your visitation
Sure.
as the non-custodial parent. They're hearing from the custodial parent that your father has a weekend visitation this weekend. So if it's not accepted or if it's breached, it's going to cause some scars there.
Right, it's going to hurt, especially it's going to let them down if I'm expecting and I want to see my dad or my mom, as the case may be, because it could be either way, and it's a disappointment. It's kind of a letdown if that doesn't happen. Now, what's really important is for the other parent, and we stress this, and this isn't just for joint parenting folks or situations, but for all type of things. Neither parent should really talk bad or badmouth the other parent in the presence of the children. They should just talk complimentary and positively about that other parent. And what it does is when you talk bad about somebody, then the child is going to pick up on that, and that's called parental alienation. And you really don't want to do that, and you essentially turn the children against the other parent.
Right, and if that's happening, you can go into court
You sure can.
and seek an order from the judge that kind of conduct be prohibited. And then if you violate it, you can be back in on a rule to show cause and held in contempt. So it is very important. It's taken very seriously. Now let's get back to custody.
Sure.
If they see you for mediation, obviously there's a dispute, there's a misunderstanding, there's not an agreement. What do you do as a mediator, as a facilitative mediator, to explain and make a recommendation?
Well, first, I think the folks should know that mediation is really negotiation with the assistance of a third party. And there are primarily three different types of mediation. You have facilitative mediation, which is what you do in divorce mediation. There is evaluative mediation, and there's transformative mediation. Evaluative mediation is when the mediator looks at both of the parties in their situation. Let's take a personal injury type of scenario. And we're coming in to try to mediate, to work out a dispute so we don't have to go to trial, and we can, the parties can save money and time and effort, and everything will be wrapped up and taken care of. And so the mediator is going to listen to both parties, they're going to look at the arguments, look at the evidence that they have, and they're going to make a determination, or they're going to make a suggestion on the strengths or weaknesses of each party's case. Now, they're probably going to go back and forth, and they call that shuttling, or they might do a caucus where they put somebody off aside and just talk to that person. But what they're going to do is they're going to tell that person, hey, your case is okay, but here are some of the weaknesses. This is what they're offering, this is what they have, and you need to consider these other issues, just so that you know. And then he's going to go to the other person and tell them, okay, you know what, true, you have these points on your side, but you need to look at this. And so that's for the purpose of being able to make an evaluation of something and to be able to kind of get rid of it.
Yeah. They're also going to look at the medical records, review the damages, the lost wages. They're going to know what jury verdicts reporters are likely to give. So they're going to have all that information that they can transform to the parties to try and bring a negotiated settlement, correct?
Right, and to try to get everybody taken care of, and so that the process is over. And again, really, it's really an expensive proposition to litigate anything, especially personal injury case. You have to have, when you go to trial, to bring in the doctors or experts, and they charge for their time, and there's a minimum amount of time that they charge for. So it's nice to get everything taken care of, so everybody is out of the box, and they can move on with their life. Because even though just the litigation has a adverse impact on people. So
one of your jobs as a mediator then, if I'm understanding this correctly, would be to instill some realistic expectations in the parties.
Well, true facilitative means that basically I'm in charge of the process, and the people are in charge of the outcome. And again, just really quickly, the transformative mediation is sort of like something that you want to happen for them to get more to a different level and a positive. I mean, when I think of that, I think about therapy, when somebody when somebody has something like that, and so something else comes out of it, they're expecting that kind of action. But with respect to facilitative, which is what you do in divorce mediation, the whole idea is to help the parties come to a decision on their own. In terms of negotiation, there's a couple of ways you can look at this. You can either take a kind of a win-lose situation. It's adversarial any way you look at it. You can take a win-lose situation and take that kind of mentality and attitude. Okay, well, I'm only giving a little bit, and we're going back and forth. Or we can look at more of a win-win situation where what we're trying to focus on is solving the problems that underlie the issues that people have. For example, someone may not want to, in terms of custody, they may not want the other person to have custody. Let's just take a situation where it might be a father who doesn't want the wife to have that physical possession, that residential custody. There could be a whole bunch of reasons for that. One reason, sometimes kind of superficial but happens often enough, is that person doesn't want to pay child support. Because generally the person who is the non-custodial parent will have to pay child support to the custodial parent, and that is as it should be.
Based on a percentage of his or her income.
His or her, right, net income. And there's a whole guideline set out in the statute, Marriage
Let's talk about that. One child would be 20%.
Right.
2 children would be 28%.
That's correct.
3 children is 32%.
32. That's
4
right.
children is 40%.
Right.
5 children is 45%, and 5 or more is 50%.
That's a tough road to hoe.
So it's a big financial burden the more children you have, and that's the net income. That's the take-home pay.
Right.
So it's a huge chunk of change.
It sure is. And so,
but it's for your children.
It's for your children. That's exactly right. You had those children. You're responsible to take care of them. And, I want to tell all the people, all the fathers out there, okay, and all the parents out there, you have an obligation to take care of your children. You might not like your spouse. You might think that she's spending the money on something else. We don't have accounting here in Illinois. That means whatever the child support goes to her, it's for the roof over the child's or children's head, it's for the food that goes in their stomach, it's for the heat that keeps them warm, it's for the clothes on their back and other things. And everyone has a responsibility to take care of their children.
Right, and the payor would have the burden of showing that the recipient is not using those funds for the children. For example, if the children are in shabby clothes, if they're unclean, if they're not fed, if the household is not maintained, that would be the argument that the child support funds are not going to their proper purpose. Maybe the ex-wife is on a frolic. Maybe she's taking vacations. Maybe she's neglecting the children. That would be a case where someone can come back in and say to the court, look, child support's not being done right with the child support in this case.
Well, I think that would be a bigger case. I think if someone's not taking care of the children, that might be an argument for possibly switching custody. I mean,
Right.
our
But you'd have to wait 2 years after a custodial order unless it's endangerment of the children.
Right, exactly.
And just having
within 2
clothes
years.
that are dirty and mac and cheese every night is not endangerment, I don't think.
Not just those couple of things.
Right.
That's true enough. But people do consider those things, and so people look at that. Sometimes the idea that they don't want the other person to have custody is because they're worried about that other person taking off with the children, or they have other issues where maybe the children aren't supervised properly, or maybe with the other parent they're around other people that are a negative influence on the children. And so what has to happen is that you have to identify and find out exactly what the underpinnings are, what's the linchpin of the problem that somebody has.
Right.
And once you identify that, you can move forward. And again, in true facilitative, the parties come to the agreement. The mediator doesn't really even suggest things. They inform them of certain things, and they ask them, okay, well, this is your problem. Well, they maybe pose a couple questions and then ask them, well, how do you think we might be able to get some language to be able to fix this?
What percentage of the custody mediations reach a conclusion that allows for the court not to get involved in that issue? In other words, how often is custody resolved so we can then move on to division of property, allocation of debt, and things like that?
That's a great question. I don't know what the percentage is, and I guess they may vary from county to county. But I can tell you, either way, it's not, some people look at it as, well, I just wasted time and I wasted some money because I had to go to a mediator. You have to be able to want to mediate.
In my experience, over 90% of the time, mediators have resolved the custody issue right at the start, before it expands into this ridiculous process in terms of time, expense, anguish. The mediator is great, in my opinion, at facilitating that issue. Unless, of course, there's no way they're going to reach an agreement no matter what the mediator says, and that's about 10% of the time.
Right. Well, you have, for court-appointed mediation, there's only two issues. One issue is, of course, custody, and then the other issue is visitation. Right. I mean, they talk about removal, but it deals with the same thing, custody, visitation. So basically, those are really only the two things, the two issues that you kind of mediate. And that gets broken down further into, okay, when we talk about medical for the children and stuff like that, that's, all in there, or,
You
spring
never
break
get into
or something
support?
like that. Never
You
get
never
into
explain
support.
to the parties
No.
what support is all about?
That's really not my, that's not what's being mediated. However, if
What if it's broached?
if
Will you
they
then
ask
discuss
if
it?
it's broached,
Okay.
right, and they have to understand and have that, understanding that they have to pay the support.
Because you almost have a
and
triad
what it
there.
is.
You have custody, support, visitation. You
Right.
kind of have a triangle of issues there that are, interlope into each other, that
Right.
one brings about another. And of course, whoever has custody, like you said, is entitled to child support. The non-custodial party is entitled to visitation. So you've got these three-headed monster that you need to deal with. And I think as a mediator, you can probably handle all those in one fell swoop.
Well, you really don't deal with in terms of the child support, and actually in recent mediation, that kind of came up, and I explained to them that, because one of the parties was talking about, I haven't received any support, or whatever. And I said, that's what your attorneys are going to handle, because that's what their job is. In a mediation, it's my job to help the people to be able to reach an agreement. Now, here's the thing.
I want you to mention, too, that the attorneys are not present
Right.
at the initial court-ordered mediation for custody.
No, it's
Very
just-
important. The attorneys are not there. It's the parties and you.
Right. It's the parties, and it's a different venue. In a recent one that I just completed, they had a four-way settlement conference before. It was both the attorneys and both the parties, and they weren't able to resolve it. And it was a different atmosphere because it's set up differently. It's, I want what I want for my client, and you want what you want for your client, and we're going back and forth. And so there's a different tone. As a mediator, again, I'm neutral.
Right.
I don't have any stake in the outcome.
This is important too. If you are familiar with either one of the parties, I'm sure you must refuse the appointment.
Right.
You can't have any bias. You have to be completely neutral. They can't know you. You can't know them. You shouldn't know any of their family members. You shouldn't know anybody from work. You are just an absolute outsider who's coming in to facilitate the mediation process.
That's correct. And in the beginning, when they come in for the initial mediation, DuPage, you have basically, it's 3 hours of mediation and 1 hour of administrative type of stuff for the mediator, which means, reviewing documents, writing letters, writing the final report, making phone calls, that kind of thing. But usually it's broken up into 2 1.5-hour sessions. And so for the first session, as part of the introduction, or the opening statement is what they call it, you tell the people, you just make sure in front of them that, hey, neither one of you have met me before, and you go through some other things, some other kind of warnings, not really warnings, but more information in terms of the ground rules, in terms of, hey, listen, nobody's going to talk over somebody, they're not going to interrupt, we're not going to make judgments, we're not going to swear or point fingers, because we're not here for that.
Right. Now, the parties are already paying their attorneys, so I'm sure fees are a concern. How is the fee structure through court-ordered mediation?
In DuPage, it is $800, which is essentially $200 an hour. So there's really 4 hours of mediation. Like I said, there's 3 hours of mediation, and then there's 1 hour for the administrative stuff for the.
Are those fees split equally?
They can be split equally, or they can be split any other way, depending upon the situation of the parties and their finances. If one party is working and the other party isn't, most likely they'll make that party pay them without prejudice. When I say without prejudice, it means that they can revisit that later and they can readjust those type of things, those type of, who's paying what. Or they can make it, you pay 2/3, this person pays 1/3, or you pay,
Okay. A lot of people believe that the court actually pays you out of the filing fees, but that's not the case.
No, that's not the case. The court-ordered mediation, you actually pay the mediator.
Okay. How about some success stories? Well, we have a few minutes left. Tell me a couple success stories that mediation has done real well with.
Well, we've actually, again, a recent one. Folks came in, and it was custody and visitation. We sat through the first session. We were able to resolve it. And that was really fantastic because it was a custody issue. And they had a whole bunch of commonalities, which was their concern for their children. And they wanted to maximize their parenting time. They wanted to spend time with them. And each party, what essentially happens is you put out a confidential questionnaire and you have people answer those. And so you review those before they come into the first session. And it gives you ideas, and you're supposed to screen as a mediator for all types of things. For example, for any types of disabilities, for any type of abuse, domestic violence, substance abuse, those kinds of things. And so if their answers to the question reveal those things, then you get a little bit further deeper into those issues. But so that's how you kind of get to have an idea. And when you see where people have answered everything pretty much the same, except in a couple of questions that are those red flag questions, and you kind of dive a little bit deeper into that scenario. And so anyway, so we did that. We were able to resolve the issue of custody after the first session.
It must feel great to help people take the weight off their shoulders, eliminate some of those issues, because the underlying divorce process is riddled with difficulties and things that need to be negotiated out. And if you can nip one or two of these big issues, it must feel great.
Right, they fall into place. I really, really enjoy doing that. And then, however, I have to tell you, because then the second time, they came in and we're just going to work out visitation. I'm just expecting, okay, we're just going to talk about the visitation schedule. And then I find out that one of the parties, the party who's going to have residential custody, doesn't want the other party to have overnight visitation.
And why not?
So,
why not? What was the reason for this?
There were a couple of reasons. One reason was she was fearful that that he was going to take the kids to Mexico.
Okay.
Out of
It's
state.
a legitimate concern, but in reality, he can do
it
that if
doesn't
he
matter.
doesn't have overnight
They're part of the
visitation.
Geneva Convention. Right.
But he can do that during his daytime.
Exactly right,
So-
and that's what we talked about. And so she had kind of an understanding that the court is going to order visitation unless there are some serious other problems, and overnight, unless the child is very, very young. But there's something that people need to understand too, that when they go into mediation, either you're going to make and come to a decision yourselves between the two parties, a decision that both of you have work to do, or you're going to put that decision, that power, into the hands of a judge. And although it could be the greatest judge in the world, okay, it doesn't matter. The problem is that this judge is only going to hear a thumbnail sketch of your situation of your life, and then he's going to make a decision that you're going to be stuck with.
Yeah.
If the parties are able to come to that agreement together, they're more apt to stay to it, and they're going to be happier because they've helped to create that agreement.
Yeah, and in all fairness, the judges don't want to make that decision. They
No,
really
they don't.
want to facilitate the parties to reach an agreement because they don't want to get involved in that kind of thing. If the parties
Yeah.
can reach an agreement on their own, it's much better than the court, who doesn't really know these parties and doesn't have a history with them, having to make an order and a ruling.
That's correct. And I mean, that's the best thing in the world when you do it yourself, because you can take the pride in that. And again, if you're focused, again, on the commonalities, which are, hey, listen, I'm just interested in what's best for my child. I'm interested, I want to spend as much time as I can with them. But then you realize, well, wait a minute, if I'm working 12 hours a day, I can't. I mean, there has to be, there has to be some kind of type of adjustment. While we still have a little time left, I would like to mention too, mediation is just not court-ordered mediation too. A lot of times people will come into mediation, and I'm certainly available for that as well, before they actually even file the lawsuit. And that also encompasses not just the issues of custody and visitation. That type of mediation can also encompass other things as well, in terms of the finances, in terms of the child support, in terms of the whole picture.
So this would be a situation where the parties are having marital problems, and before they go and seek attorneys and file things into the court, they talk amongst themselves and say, why don't we try to mediate this ourselves,
Right.
without court intervention?
Right. If they can't agree on certain things, and they'll do that. And to tell you the truth, people are doing that more and more because they save a whole lot of money when they're doing that. And then what happens is after they've been able to come to an agreement, hopefully with the assistance of the mediator, and and in that kind of case too, a mediator can certainly write out an agreement if he or she's an attorney. If they're not, I mean, they can certainly do the visitation schedule. And then what happens is they get referred to attorneys, because you can't, as a mediator, after you're a mediator, you can't then go ahead and represent one party or the other. You have to refer them out.
Okay, but you as an attorney, if someone is referred to you after mediation, do you incorporate the agreement they already have into new documents, or do you prepare a judgment that just attaches that mediation agreement as an exhibit?
We incorporate it into a new cohesive
Because
document.
I've seen it done both ways, and one way to me is the lazy way.
No, I don't, I like things cohesively. I generally don't have anybody sign things because, again, it's really not binding until the attorneys have to look at it, and then it's not going to be binding until the parties sign it, and then until the judge signs it. So it really doesn't matter. So if somebody signed it, but I think the way to do it would be to incorporate it into that cohesive document so that it runs clearly. Because sometimes you have different language, and you have to fit it in there carefully and artfully when you're drafting that particular document, so that there's no question.
Now, real briefly, you are on the list of mediators in DuPage County.
That's correct?
Correct? But you are also available privately in all the counties.
That's correct.
Okay, so if someone wants to get a hold of you, they can contact the show and talk to you about that. Or if they have any questions, they can reach you. And you also co-wrote a book, Divorce and Family Law, Who Has the Legal Right When Things Go Terribly Wrong? And some of these items are talked about in your book, is that correct?
That's correct. Some of those items are talked about. It's a good kind of reference guide to give people an idea without any highfalutin talk, just a basic good idea of what's going on.
Right. Well, thanks for being here, Jesse. Great information.
Thank you, Dave.
I hope most people don't need it because it's always involved in a divorce or family law case. But hope you enjoyed watching Legal Action. We'll see you next time. Take care.